he had put in versus what he had in the charge.
Oh, where's my phone?
Yeah.
Give this to your cohort when he shows up.
All rise, please. Circuit court is back in session.
Thank you, PG.
I was trying to use a different computer for Zoom, but it's updating, so I'll use my laptop.
This is for Monday's topic. It's for Monday's topic.
Why is it? You got it.
I'm trying to get everything ready for you.
Okay.
What do you guys have Monday? Just the keys. Anything else like this? We've got docket tags, so it's fine.
Okay, we're here on the 1:30 arraignment docket. Ms. Jakewood, are you ready?
I am, Your Honor. Your Honor, I have Devaris Townsend on the docket at 1:30, and he's an inmate 22 CF 1207.
Townsend?
And Your Honor, if I may just pause a moment and have Mr. Townsend sign.
Yes, ma'am. Yes, ma'am. Thank you. Yes, ma'am.
Thank you, Your Honor. Because this was a very quick turnaround from me getting appointed, I don't actually have a score sheet for the court, but this is going to be a guideline sentence. In this case, Mr. Townsend is going to plead no contest as charged. He'll be adjudicated guilty, placed on 18 months of probation. He'll need to pay the $40 per month cost of supervision, $515 in court costs, a $150 cost of defense. He'll need to pay $1,947.44 restitution to Walmart in Fort Walton Beach. That will be joint and several with his co-defendant, Shanavia Greenwood. The probation is concurrent to his probation imposed in Bay County. And in return for this plea, the state will take no action on any failure to appear.
Okay.
And Your Honor, Mr. Townsend is an out-of-state resident. He was at the time of this offense. I have made him aware of the $100 transfer fee that he'll have to pay before he's able to return to Alabama. And so he's aware of all of that information, and for probation's benefit, he is a resident of another state. And Your Honor, we would just ask that he be allowed to report to probation first thing in the morning. By the time he gets back to the jail, it's unlikely that he'll be able to get down there before 5 p.m.
Thank you, ma'am.
May I approach?
Please. Mr. Townsend, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Townsend, are you currently under the influence of any drugs, alcohol, or medication?
No.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did she answer all of your questions?
Yes, sir.
Are you satisfied with her representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Townsend, I do accept your plea. You're adjudicated guilty. You're sentenced to 18 months probation, and that's concurrent with your supervision in Bay County. You need to pay the $40 per month cost of supervision. All monetary assessments mandated by statute or a county ordinance are imposed. That's the court cost. $150 public assistance fee. Pay restitution in the amount of $1,947.44 to Walmart, and that's joint and several with your co-defendant. Court has no objection to you transferring your supervision out of the state of Florida. You will need to report to probation tomorrow morning at 8 o'clock. Thank you, sir. Good luck to you.
All right, thanks.
And Your Honor, I do have one non-inmate on today's docket, if that's okay. Katrina Reno in 23 CF 53. Ms. Reno?
Ms. Reno? She on 130?
Yes, Your Honor. I was just appointed yesterday. That's RENO. And in Ms. Reno's case, there were multiple co-defendants in this case, and witnesses, and there's a lot of activity at that address as far as co-defendants and witnesses and things of that nature, and so my office does have a conflict with this case. We just did not have sufficient time to file the motion, and I wanted to make sure that Ms. Reno was informed of that, so I didn't have my legal assistant file a written plea of not guilty to remove her from the docket. I don't know if Ms. Reno is interested in hearing an offer from the state attorney's office, if they have one, but...
Okay. Does the state have an offer for Ms. Reno?
Not at this time, Judge.
Okay, so kind of went through that kind of quickly. So you're saying you're not entering a plea of not guilty?
I will now, Your Honor. I didn't want to do it ahead of time because I wanted to make Ms. Reno aware that she would be getting a new attorney.
Okay.
I don't know who that will be yet.
Okay, so you have received the information?
Mm-hmm. Yes. Yes.
Okay. So Ms. Reno, all that means is that I'll see you back here on March 13th at 9 o'clock. That's the pre-trial conference. And the Regional Conflict Counsel, Ms. Jacob, will file a motion to withdraw. I will sign that, and then I'll appoint another attorney to represent you, and they'll either give you the information where you can contact them, or they'll contact you, okay? March 13th, 9 o'clock, back here. Thank you, ma'am.
So if you'll just call my office and hit extension 2, talk to my legal assistant Kim, maybe next Wednesday or Thursday, she'll tell you who the new attorney is. And I put 313 for your next court date is on there as well. Thank you. Yeah. That's all I have on 130, Mayhew.
Thank you, ma'am.
Thank you.
Mr. McKinney?
Yes, Judge. We're starting with Eddie Hudson.
Mr. Hudson? Eddie James Hudson Jr., I don't see him, we'll pass him.
Stephen Lowe. Mr. Lowe is present and approaching.
Thank you.
Mr. Lowe is represented by Mr. Kleins. At this time, we would acknowledge a three-count information, waive this formal reading and or plea of not guilty. This is already set for the 13th of March at 9 a.m.
Okay. Has the state made you an offer, do you know? Does the state have an offer for Mr. Lowe?
Yes, Your Honor, it would be an adjudication of guilt, 3 years of probation, $615 in court costs, a PD fee, substance abuse evaluation and within 30 days, and to begin a recommended treatment within 60 days, 24 hours of community service work.
Okay, thank you. Mr. Lowe, I'll see you back here on March 13th at 9 o'clock.
Yes,
Stay in touch with Mr. Klein. Thank you, sir.
Enriquez McCorvey. Mr. McCorvey is present and approaching. We would acknowledge the receipt of one-count information, waive its formal reading and or plea of not guilty. Mr. McCorvey is also represented by Mr. Kleins, and he's set for March 13th at 9 a.m. unless the state has an offer today.
And I hesitate now, Mr. McCorvey, after the last one, if someone's not incarcerated and the state's offering probation, usually the defendant wants to talk to their attorney before that. If somebody's incarcerated and the state offers something that may get them out, I think that's more likely. And so, Mr. McCorvey, I'll see you back here on March 13th at 9 o'clock. Get in touch with Mr. Kleins and stay in touch with him, okay?
All right.
Thank you, sir.
Thank you.
There's a Monshell McGriff. Judge, we would need to continue this to another plea day. I don't believe an information has been filed in this case. I've spoken about it with Mr. Gomez. I believe if we continued it one more time, we'll be able to reach some sort of agreement.
Yes, Your Honor, I'm trying to work through this. There's a lot of really interesting paperwork that's a little bit different. It's like the incident that was cited in the immediate arrest report was a 2022 incident, but then all the paperwork that we're receiving is from a warrant from a 2021 incident. So I'm trying to work through that to make sure that if we are going to move forward at all, that we move forward in the appropriate court, whether that be in this incident or here. If you can just give me maybe 30 more days, by the end of that, I'll either have it transferred down, dismissed, or if we're going to move forward here, I'll have the information filed.
Okay. What is educate the court, what's the time period on when the state has to file the information after the arrest? And then what are the consequences of that?
Typically, the remedy would be an ROR bond, given that Ms. McGriff is out on bond or out of jail already. There's not really a whole lot of remedy.
Okay. And Your Honor, we stipulated that bond, just for the record, we stipulated that bond knowing of these circumstances. We were not about to try to keep Ms. McGriff in jail. And so that's why we stipulated that bond while we try to figure this out.
So, Ms. McGriff, I'll see you back here on March 16th at 1:30. Okay?
Thank you.
Thank you, ma'am.
Brian Pippin. Mr. Pippin is also represented by Mr. Kleins. I'm providing contact information at this time. We would acknowledge the receipt of a two-count information, waive its formal reading, enter a plea of not guilty. This is already set for March 13th at 9 a.m. We'd like to leave it there.
Okay. Mr. Pippin, I'll see you on March 13th at 9 o'clock. Stay in touch with Mr. Kleins. Thank you, sir.
Eric Richardson, followed by Jeffrey Ross. Mr. Richardson is approaching in 23 CF 21. I'm providing my contact information at this time. Is there any information that's been filed in this case?
Yes. I filed everything
Madam Clerk
The
doesn't.
10th was the last date that I filed for this court date.
Is it a one-count information?
What was the last name?
Richardson?
Eric Richardson. Should have been filed on February 10th for a one count of possession of a controlled substance.
Judge, we would enter a plea of not guilty. This is already set for March 13th. I believe that if we forecast ahead, we're likely heading towards some sort of a PTI agreement anyhow. So I would like to maintain the not guilty plea and come back on March 13th.
Okay. Mr. Richardson, I'll see you on March 13th at 9. Stay in touch with Mr. McKinney. Okay?
Yes, sir.
Thank you, sir.
Okay, make an appointment. Come to me, okay. Jeffrey Ross. Hey there, how are you? Judge, we would acknowledge a one-count information, waive its formal reading, enter a plea of not guilty. This is set for March 13th, and speaking to Mr. Ross at the podium, he wishes to come in and speak with me further. So we'll enter the plea of not guilty.
Excellent. Mr. Ross, good. I encourage you to stay in touch with your attorney.
Yes, sir.
Can only help you if you stay in touch with
Yeah, I just got a letter from him yesterday, so.
Good. So I'll see you back here on March 13th at 9 o'clock. Yes, sir.
It's right here.
Oh, thank you so much.
So schedule an appointment, come in and see me before that.
Yes, sir. Thank you.
Mr. McKinney, Teresa just came in. Do you have a case with her?
There's an unrepresented defendant in the audience, Your Honor.
Yes, ma'am, please.
His name is Zúñiga Anariba Nelson. Zúñiga with a C.
Thank you.
Señor Zúñiga, pase.
His last name starts with a C, Teresa? Z. Gotcha. Okay, thank you. If you don't mind swearing in.
Swear or affirm that you will be accurate and partial interpretation of the Spanish and English language and vice versa relative to the cause and under consideration before the court.
I do.
Thank you, ma'am. Does the state have an offer for Mr. Zinke?
You can find the file, Judge. But to be honest, Judge, I think at this point with requiring an interpreter, not working on this one. I don't think that it would be appropriate to take a plea today without a little bit more representation for Mr. Zúñiga.
Well, it depends on what the plea is. I mean, if the offer is something that, I don't know what you're going to offer, so that's what
It's
I'm
going to be
wondering,
in your
Mr.
probation, Judge.
Okay. Mr. Zinke, have you ever been on probation in the past?
No.
Okay. Mr. Zinke, do you wish for me to appoint the public defender to represent you if you qualify financially?
Yes.
Yes.
Okay. How much money do you make per month?
Around $4,000.
Okay. Mr. Zinke, you're probably not going to qualify for the public defender, so I can't appoint one for you. You were handed the information that shows that you were charged with possession of counterfeit license plate and operating a motor vehicle without a valid license. That's why you're here. I will enter a denial for you of those charges. You'll need to hire a private attorney if you wish for an attorney to represent you to the state. Do you want to tell Mr. Zinke the offer where he can tell his attorney, or do you just want his attorney to contact the state?
It'll just come in the discovery package, Judge. So with the score sheet as well.
Okay. So, Mr. Zinke, any attorney would tell you that you should hire an attorney. Okay. So I'd recommend that you hire an attorney. I'll see you back here on March 13th at 9 o'clock. Hopefully you'll have an attorney with you. If you don't, then you'll be representing yourself. Ultimately, we'll be heading toward a jury trial if it's not resolved before then.
Perfect.
Thank you, sir.
Perfect.
Thank you. Mr. McKinney?
Gregory Seward, followed by Isaiah Soto.
Good afternoon, Your Honor.
Good afternoon, Mr. Seward.
I am Jason McKinney. I represent Mr. Seward. One-count information will waive its formal reading at this time. Will enter a plea of not guilty. This is set for March 13th at 9 a.m. We'd like to stay on that date.
Okay. Mr. Seward, I'll see you on March 13th at 9. Stay in touch with Mr. McKinney, okay?
I'll be there.
Thank you, sir.
Mr. Soto?
Yep.
I see that information. Provide my contact information. There's my contact information. Judge, we will acknowledge the receipt of a one-count information, waive its formal reading, and enter a plea of not guilty. This is already set on March 13th for a pretrial.
Okay. Mr. Soto, I'll see you then, March 13th at 9.
Thank you, sir.
Thank you, sir.
Cheryl Swanigan, followed by Ann Waite. I'll try to do better. Did I give you my card already? Yes. Okay. Judge, we would acknowledge a two-count information, waive its formal reading, and enter a plea of not guilty. This is set on March 13th at 9 a.m. We'd like to leave it there.
Ms. Swanigan, I'll see you then, okay?
Yes, sir.
At 9 on the 13th.
Yes, sir.
Thank you, ma'am.
Nope, I just circled the date of when you need to come back.
Thank you.
Just make an appointment to come see me.
Yes, sir.
Ms. Waite? Judge, we would acknowledge the receipt of a one-count information, waive its formal reading, and enter a plea of not guilty. This is scheduled for March 13th at 9 a.m.
Okay. To the state, because of the charge against Ms. Waite, any offer you want to make to her today?
Not at this time, Judge.
Okay. Ms. Waite, I'll see you on March 13th at 9, okay? Thank you, ma'am.
Thank you.
Make an appointment to come talk to you, okay? Kayla Warden. Followed by David Whitney. Ms. Warden is before the court in a two-count information. We'd waive its formal reading. Does the state have an offer for today?
Warden, W-A-R-D-E-N. Good afternoon, Ms. Warden.
Just because I'm asking about the offer.
Judge, at this time, we would do withhold and court costs.
Judge, may we call her back so I could speak to her about what that means?
Certainly. Ms. Warden, I'll see you in a little bit.
Leave. Mr. Whitney is before the court in a five-count information. Will waive its formal reading and her plea of not guilty. He's already set for March 13th at 9 a.m. We'd like to leave it on that court date.
Yes, sir. Mr. Whitney, I'll see you back here March 13th at 9. Stay in touch with Mr. McKinney, okay?
Yes, sir.
Thank you, sir.
Okay, make an appointment to come see me. Judge, I have one matter who's an inmate. Mr. Williams, do you want me to take that now?
Sir.
Gregory Williams.
Hello again, Mr. Williams.
And Judge, since we've reconvened, I was appointed this morning by the court to Mr. Williams' case. In speaking with the state and Mr. Williams, it sounds like that they have reached an agreement really without my help. So I would ask the court to consider just allowing Mr. Williams to enter a plea pro se. I've spoken to him about the terms, and I've spoken to him as a friend of the court to save him some money on the PD application, since I really didn't do a whole lot today. The terms of the agreement for Mr. Williams would be to enter a plea to a lesser included misdemeanor battery for 1 year of probation to be supervised by JCS. On the 1 year probation, he would have to complete a mental health evaluation, have no alcohol, be subject to random breath testing, and have no violent contact with the victim who is present in the courtroom.
Okay. And there'd be court costs, correct?
Yes, Your Honor.
And JCS charges $15 a month, right?
$50 a month.
$50, I'm sorry.
Yes, sir.
Okay. Mr. Williams, I do relieve the public defender and don't appoint them, unappoint them. So let's talk a minute, Mr. Williams. If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can put your hand down. So first off, Mr. Williams, what we talked about this morning, the state had stipulated to a signature bond. I just don't want you to feel any compulsion that you have to enter this plea in order to get out of jail, because you'd be getting out anyway. So do you understand that if I accept your plea to the lesser included offense, and I'm sorry, the adjudication was what?
It'd be an adjudication, Judge.
And it's a misdemeanor?
Yes, Judge. He's currently on misdemeanor probation for a DUI.
Okay. So, Mr. Williams, if I accept your plea, you'll be waiving your right to a trial by jury. Is that what you wish to do? Is that yes?
Yes, sir. Yes,
Okay.
sir.
Do you have any questions for the court or for the state?
No, sir.
Do you understand what you'll be sentenced to? Is that a yes?
Yes, sir.
Mr. Williams, I do accept your plea. You're adjudicated guilty of the lesser included offense, the misdemeanor. You're sentenced to 1 year probation with JCS. You need to pay them $50 per month for the cost of supervision. Submit to a mental health evaluation within 30 days from today. If any treatment's recommended, begin that within 60 days from today. Have no alcohol during this 1 year probation. You'll need to submit to random breath tests. Have no violent contact with the victim. And you'll need to pay the court costs.
Yes.
Okay. Thank you, sir.
Judge, just to be clear for the record, I did have an opportunity to speak with my victim about this, and this is her agreement as well.
Good. Thank you, ma'am. Thank you, sir.
Can I have a statute
Madam Clerk, it's 784-03-1 sub B.
Mr. McKinney, who's next?
Judge, I believe that's all I have. If the court wants to go down the unrepresented.
Yes, sir. Thank you. Jonathan Lonazak. 23 CF 130. Lonazak, is that how you pronounce it? Lonzak. Good, I like that. Mr. Lonzak, do you wish for me to appoint the public defender if you qualify financially?
Yes,
How much money do you make per month?
like 25.
2,500?
Yeah.
Okay, you may not qualify for the public defender. You can fill out a financial affidavit. If the clerk says you don't qualify, you can appeal that to the judge. We've got a little more latitude. We look at the totality of it. So at this point, I can't appoint the public defender to represent you. You were just handed that information that charges you with carrying a concealed firearm. That's why you're here. I do enter a denial for you. I'll set it for the pretrial conference on March 13th at 9 o'clock. If you don't qualify for the public defender, you'll need to hire a private attorney, or when you show up, you'll be representing yourself, okay?
Yes, sir.
So March 13th at 9.
Yes, sir.
Thank you, sir. Next is, did we do Brandon Lee before? Nope. Brandon Lee. 22 CF 1380. Mr. Lee, come on up. Mr. Lee, how old are you?
16.
16? Your dad can certainly come up.
Thank you, sir.
Yes, sir. You're Mr. Lee?
Uncle, Mr. Harmon.
Mr. Arnold?
Harmon.
Harmon. Thanks, Mr. Harmon.
Yes, sir.
So, Mr. Lee, you're charged with fraud, non-disclosure, changing status to the state. Tell me exactly what this charge is. I don't think I've ever seen it.
Judge, I'm also trying to figure out, I was not the attorney that filed on this, and I'm trying to figure out how.
Public aid, is it defrauding for public aid? That's what it looks like.
Yeah, I'm trying to, I'm looking, I'm trying to figure out how it's possible that somebody that is Mr. Lee's age could get discharged.
Good.
Excuse me, Your Honor. He's not Brandon Lee Thomas. We're here in the wrong representations for Brandon Lee. His name is Brandon, and he has an attorney, but we're not Brandon Lee Thomas. We apologize.
No, not a bit. What's your last name?
Lanukes.
Luke's?
Lanukes. Brandon Lee Lanukes. He's on
Oh,
Lanukes.
okay.
Okay.
But we'd like to take that lesser charge that we had.
So you're
God's good.
Teddy Lee Lanou.
Sir,
Teddy Lee Lanou?
that's my uncle.
Okay, and, okay.
Judge, if this is Mr. Lanou, your name is Brandon?
Yeah, Brandon.
So if I'm not mistaken, I believe, and you can correct me if I'm wrong, I'm not trying to put words in your mouth. I believe, do you guys have an attorney?
I believe it's
Mr. Powell. Okay, so we were here today, I am actually covering for Mr. Rogers, just to refresh the court's recollection, there was a motion to transfer divisions in this case. Mr. Powell objected to that, and so Mr. Rogers said, let's have a hearing, and that's actually the hearing that we're here today on, is Mr. Powell wanted to make an argument as to why they're not allowed to transfer divisions.
Okay. Is it set for 1:30 or 2:30?
2:30, sir.
Okay.
2:30.
So let's wait until 2:30 and hopefully your attorney will show up.
Absolutely. Thank you for your time.
Thank you. Thank you.
I was like, how does he get discharged?
Okay, so Brandon Thomas Lee, 22 CF 1380. This was noticed for 1:30. It's now 2:02. What does the state seek?
The state would request a KPS, Your Honor.
KPS will be issued for Mr. Lee, and the first appearance judge will determine the bond. So we appreciate you all being here. They'll arrest Mr. Lee and bring him to the court. Andricus McCordy, we did that, I believe. Alyssus McGinnis. Alyssus Renee McGinnis, 23 CF 69. Hello, Ms. McGinnis. Hello. Does the state have an offer for Ms. McGinnis, or do I need to?
Yes, Your Honor. This time, we would offer an adjudication withheld, 2 years of probation, $615 in court costs, $100 cost of prosecution. She does not have an attorney at this time. A substance abuse evaluation within 30 days, and the beginning of recommended treatment within 60 days, and then 24 hours of community service work.
Okay. Ms. McGinnis, have you ever been on probation before?
Not in the state of Florida.
Okay. So here are your options.
Yes, sir.
You have the right for me to appoint an attorney if you qualify financially. You have the right to accept the state's offer and waive an attorney, waive your right to a trial by jury. You'd be on probation for 2 years. You'd have to pay court costs, $40 a month for the supervision, the probation. You'd have to submit to a substance abuse evaluation within 30 days from today. If any treatment was recommended, then you'd have to begin that no later than 60 days from today and perform 24 hours of community service work. What do you want to do?
I will take a public defender, sir.
Okay. How much money do you make per month?
About $1,800.
Okay. I do appoint the public defender to represent you. Mr. McKinney's approaching on your right. Sure.
I'm providing Mr. Klein's information at this time. Sure, she's already completed it.
Good, thank you, sir.
We would acknowledge a one-count information, waive its formal reading and a plea of not guilty. This is set for March 13th at 9 a.m.
Okay. Ms. McGinnis, March 13th at 9. I'll see you then. Stay in touch with Mr. Klein.
Yes, sir.
Thank you.
Sure.
Raymond Morgan, 23 CF 44. Oh, Mr. Morgan. Does the state have an offer from Mr. Morgan?
Yes, Your Honor, it's going to be an adjudication of guilt to the charges as they're stated, guideline sentence. The guideline in this case would be 25.8 months, standard fines and court costs, no trespass. Yeah.
Okay. Mr. Morgan, do you wish for me to appoint the public defender if you qualify financially?
Yes.
Okay. How much money do you make per month?
No.
How long have you been unemployed?
Wow. It's about, it's been a minute.
How long? A minute,
4
don't
months,
qualify.
5 months.
I'm sorry, how many
45
months?
45 months.
Okay, how much money were you making per month before that?
I'm like 21 every 2 weeks.
Okay.
Let's say about 5.
Mr. Morgan, I'm not going to appoint a public defender for you today, but I encourage you to fill out a financial affidavit.
That's okay. I was in court the 13th. I was told that I had to get a pro bono or something like that because of, so I don't know. They told me I couldn't get a public defender for some reason.
Okay.
I may be able to clear that up for you.
Good, please.
You have a misdemeanor case as well, Mr.
Yes,
Morgan.
ma'am.
Mr. Morgan's case in misdemeanor court had several co-defendants, and I believe the PD's office has, I don't remember their names, but the PD's office kept one, my office has one, and we've had to withdraw from Mr. Morgan's misdemeanor cases. I cannot recall if we've received an order appointing a new attorney or not, but certainly he was determined to qualify in misdemeanor court, so I don't know if that makes any difference for the court.
Yes, ma'am. Good. Thank you, ma'am. Mr. Morgan, so I do appoint the public defender. Mr. McKinney's on your left.
And as stated, there's probably going to be a conflict analysis that I'm making notes for right now, but for today's purposes, Jason McKinney, on behalf of Mr. Morgan, will acknowledge the receipt of 2-count information, waive its formal reading, and plea of not guilty. This is set for March 13th at 9 a.m.
Thank you. Mr. Morgan, March 13th at 9, okay?
Yes, sir.
Thank you, sir.
That means
Did we already do Anthony Patterson?
Yes, Your Honor, we did.
And we did Roosevelt Peterson, correct?
That is correct, Your Honor.
Paris Pryor, 23 CF 95. Well, Mr. Pryor. Mr. Pryor, do you wish for me to appoint the public defender if you qualify financially?
No, sir.
Okay, you're going to hire a private attorney?
Yes, sir.
Okay. Mr. Pryor, you're charged with drug possession, controlled substance without a prescription, fleeing and eluding a police officer at a high speed, and driving with a suspended license or revoked license. That's why you're here. I do enter a denial for you, so I'll see you back here on March 13th at 9 o'clock with your private counsel. Hire them sooner than later so they can start working on your case, okay?
Yes, sir.
Thank you, sir.
Have you guys filed an information, because there was not one in the case?
Mr. Pryor, hold on. I jumped the gun. If there's no information, I can't do all that.
There is an information that has been filed, and it's oddly enough February 6th again, same date as the Patterson one. So I don't know what's going on.
So everything I told you, Mr. Pryor, is still accurate. So how will Mr. Parr get a copy? He was just handed a copy of the information? Good.
I don't, sir.
Okay, thank you, sir. Lincoln Ricketts is next. '23 CF 84. Lincoln Anthony Ricketts. I don't see Mr. Ricketts. It was noticed for 1:30, it's now 2:10. What is the state seek?
KPS judge.
KPS will be issued for Mr. Ricketts, and the first appearance judge will determine the bond. Mitchell Smedley is next. I don't see Mr. Smedley. It's 23 CF 115.
I'm sure there was no cross.
Okay. So 23 CF 115 was null pros.
It was a fugitive from justice, and they can't pick him up.
Okay, so that's dismissed. Christopher Smith.
We dealt
We dealt with it this morning, Judge.
Good, thank you. Christopher Stagner. 23 CF 67. Does the state have an offer for Mr. Stagner?
And withholding 1-year probation.
Okay. Mr. Stagner, have you ever been on probation before?
Way when I was younger.
Okay. So you have the right to an attorney if you qualify financially. You have the right to an appointed attorney. You can always hire a private counsel. You have the right to waive that. You have the right to waive a jury trial, accept the state's offer of withhold of adjudication, 1-year probation. There'd be $40 per month cost of supervision, and then you'd have to pay the court cost. Do you want an attorney? Do you want to represent yourself? What do you want to do?
What is it? Did you just saying this?
1-year probation.
Let's just
It
do
would be
that.
a withhold of adjudication. So you
What's that
wouldn't.
mean?
I'm sorry.
What does that mean?
Withhold means that you're not determined to be a felon.
No.
Okay, so it'd be a withhold of adjudication. You'd be sentenced to 1-year probation. If you have any questions, I can certainly appoint.
No, sir, that's fine. I mean,
Okay.
if it's just a probation, that's fine with me.
Okay, if you'll raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. You can put your hand down. So, Mr. Stagner, do you understand that if I accept your plea, that you're waiving your right to an attorney?
Yes, sir.
And that you're waiving your right to a trial by jury?
Yes, sir.
Do you have any questions for the court or the state?
No, sir. I
Mr.
messed
Stagner?
up. It was my fault.
I'm sorry?
I said I messed up. It was my fault.
Mr. Stagner, I do accept your plea. Adjudication is withheld. You're sentenced to 1-year probation.
Be random year analysis and 15 hours of community service.
Now they're changing the rules on it. UAs, what else?
15 hours of community service, Judge.
Okay. Mr. Stagner, since that isn't what we originally discussed, if you don't want to accept that plea and you want me to appoint an attorney, I can certainly do that.
Or a public
So
defender.
here's
If we
what
can
this-
do that, yeah, let's do that.
An attorney?
Is that a public defender? Or?
Yes, sir.
Yeah, let's do that because I don't know what none of this means.
Okay. Good answer. How much money do you make per month?
I'm not employed right now. I work for myself sometimes.
Okay. How much money do you average making per month over the last 6 months?
I have no clue. I work
Give me
when I
some
can.
average.
Just do like 500 or something like that.
A month?
Yeah, I don't work that much.
Okay. I do appoint the public
all this
defender.
stuff's paid for, so I stay at the house.
Mr. McKinney's on your left.
All right. How are you?
Are you fine? Judge, I'm providing my contact information at this time. We will acknowledge the receipt of a 2-count information.
Yes, sir.
Waive its formal reading and or plead not guilty. This is set for March 13th at 9 a.m.
Mr. Stagner, I'll see you March 13th at 9, okay?
Yes, sir. Thank you, sir.
Thank you, sir.
You can take this, fill out everything, and turn it in, Mr.
sir.
Did we do Richard Tatro?
Mr. Tatro is here.
Richard Tatro? Mr. Tatro, 22 CF 3114. Good afternoon, sir.
Good afternoon.
Does the state have an offer for Mr. Tatro?
It's going to be a plea as charged, adjudication, 90 days county jail, $615 in court costs, public defender fee if applicable, and cost of investigation to Niceville Police Department for $83.72.
Mr. Tatro, I'm smiling because after the last time that Ms. Davis told me the plea terms, she didn't tell me all those and he accepted them, so I'm
Right.
smiling because she wanted to make sure that she said everything in this one.
Right.
Mr. Tatro, I assume that you don't want to go to jail for 90 days.
No, sir.
You wish for me to appoint the public defender if you qualify financially.
I do.
How much money do you make per month?
Net probably around 1,800.
Okay, I do appoint the public defender to represent you. Mr. McKinney's on your left.
Judge, we would acknowledge the receipt of a 3-count information, waive its formal reading, to enter a plea of not guilty. This is set for pretrial on March 13th at 9 a.m.
Mr. Tatro, I'll see you on March 13th at 9. Stay in touch with your attorney.
Yes, sir.
Thank you, sir. Daniel Van Grain, 22 CF 3125. Good afternoon, sir.
Good afternoon, Your Honor.
Since the bailiffs have been handing me different financial affidavits, did they hand you one of those earlier?
I did, no, you guys concluded I was non-indigent when I applied for it earlier.
Okay.
So,
Does the state have an offer to Mr. Van Grain?
A withhold adjudication as charged, be court costs in the amount of $615. If he does not accept that at this point, then we're going to have to add the misdemeanor DUI into this case, and we go forward on all 4 charges here. Right now, they're separated. I was just going to do the withhold on these charges.
Okay, so all the downside to Mr. Van Grain would be a withhold of adjudication, wouldn't be adjudicated as a felon, and he'd have to pay the court cost. And I'd ask Mr. Van Grain how long he needed to pay $615.
I can do that today. I've been saving up for a lawyer, but I can do that today.
Then how about I'll give you 10 days to pay that, just to make sure that something doesn't go sideways. You'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can put your hand down. So, Mr. Van Grain, if you accept the plea and I accept the plea, then you're waiving your right to an attorney. Do you understand that?
For which case?
For the narcotics equipment, drug possession, controlled substance, resisting officer obstruction without violence.
Okay, so that's being separate from the DUI and we'll deal, okay.
Yes, sir.
Yes, sir.
Okay. So do you understand you're waiving
I do.
an attorney for that case? Is that a yes?
Yes, sir.
Okay. Do you also understand that you're waiving your right to a trial by jury?
Yes, sir.
Do you still wish to enter the plea?
I do.
Mr. Van Grain, I do accept your plea. Adjudication is withheld. You will need to pay the court cost. If you fail to pay those within 10 days from today,
I get a pen to write down the court cost?
$615.
Thank you very much.
The clerk's office probably won't have that process today, so
Today.
we can give a period of time.
Yeah, I just got 10 days. All right, thank you so much.
15. So if you fail to pay that within 10 days from today, then it will go to a civil lien or judgment.
Oh, no, that'll be one lump sum. All done.
Okay, good.
All right.
Thank you, sir.
The DUI, do I have to come back on the 13th?
I don't have the DUI.
I don't have the DUI.
Is that county or state?
It's county court.
I have another court date on the 13th of March. So
Good,
I
and
just
that's
come in.
county court, and that's when you need to be here.
All right. Thank you very much.
Thank you, sir. Okay, then we'll come back to Mr. Walker. Jericho White. 22 CF 3194. Hello, Ms. White. Does the state have an offer for Ms. White that you think she may accept without an attorney, or do I need to appoint one?
No, Judge. Not this time, Judge.
Ms. White, do you wish for me to appoint the public defender if you qualify financially?
Yes, sir.
How much money do you make per month?
None right now due to a car accident. I'm on doctor's leave right now.
Okay, how long, well, okay, do you have any, how long have you been without a job?
Since August of this past.
I do appoint the public defender to represent you.
Thank you.
Judge, we would acknowledge the receipt of a one-count information waive its formal reading and that you plead not guilty. This is currently set for March 13th for pre-trial at 9 a.m.
Ms. White, I'll see you on March 13th at 9. Stay in touch with Mr. McKinney.
Thank you, sir.
Thank you, ma'am. We did Mr. Williams' case. Ryan Matthew Williams, 22 CF 3147. Good afternoon, sir. Does the state have an offer for Mr. Ryan Williams? Ryan Williams?
No, Judge, not at this time.
Okay. Mr. Williams, do you wish for me to appoint the public defender if you qualify financially?
Sure.
How much money do you make per month?
$2,000.
Okay, I do appoint the public defender to represent you. Mr. Gates, this is Ryan Williams or Mr. McKinney?
Providing my contact information at this time, Judge, we would acknowledge the receipt of a one-count information waive its formal reading and enter a plea of not guilty. This is set for March 13th at 9 a.m.
Mr. Williams, hold on one second. Two things. One, I'll see you on March 13th at 9. Stay in touch with Mr. McKinney. When you come back, my Spanish teacher would say, chicle. Don't bring gum into the courtroom, okay? Thank you, sir.
Thank you.
Yeah, that's all the pro se's I have other than the one inmate that's in the back. Mr. McKinney, do you have other folks?
Ms. Kayla Warden, if we could recall her.
Certainly.
Ms. Warden is here in 22 CF 3170. We've reached an agreement with the state. Ms. Warden wishes to enter a plea as charged for an adjudication of guilt and court cost, $615 in court cost, $150 cost of defense. May I approach?
Yes, sir. Ms. Warden, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. Ms. Warden, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Ms. Warden, I do accept your plea. Adjudication is withheld.
It's adjudicated guilty.
To a lesser included?
No, it's adjudicated guilty. She's previously been adjudicated in another case.
Okay. I had written down withhold when she was up before, but that...
That's what the state announced. However, she does have a prior adjudication.
Okay. Ms. Warden, you're adjudicated guilty. You'll need to pay the court costs, the $150 public defender's fee. How long do you want to pay that?
Can we do that maybe like 6 months?
Yes, ma'am. So if you fail to pay that amount within 6 months, then it will go to a civil lien or judgment, okay?
Yes, sir.
Thank you, ma'am.
We pay that close to the court, which is the house.
Okay. Mr. McKinney, you have anybody else on the 130 docket?
No, Your Honor.
Anybody else here in the gallery for 130? Yes, ma'am. Yes, ma'am.
Crystal Ross?
Ross? Madam Clerk tells me that Ms. Ross's attorney filed a not guilty plea, and so I will see Ms. Ross back on March 13th at 9 o'clock. Thank you, ma'am. So then on the 2:30 docket, from shortest to longest, where do we want to start? Mr. McKinney, Ms. Jakefoot,
Mr. Stevens.
Mr. Stevens, as far as length, do you have anything short? Okay, thank you. Let me know when you're ready.
Mine is just a status, Judge, on Mr. Smedley.
Yes, sir.
Mr. Smedley's an inmate.
And we're ready for Mr. Smith.
I'm hot about it. Now you have to give me a second.
Hello, Mr. Smedley.
Mr. Smedley is before the court in 5 case numbers, 22 CF 1685, 22 CF 1961, 22 CF 1962, 22 CF 1963, and 22 CF 1964. The court has previously found Mr. Smedley incompetent to proceed, but deemed that he needs to do competency training at the Okaloosa County Jail in lieu of a conditional release plan, and he doesn't meet the criteria for Florida State Hospital. I have reached out and spoke with John Barnes, who does the competency restoration for Okaloosa County, who is putting a plan together and is intending to do the competency restoration for Mr. Smedley at the Okaloosa County Jail. Today we've set this as a status date just to make sure that we're on track and all the moving pieces are moving forward so that Mr. Smedley doesn't fall through the cracks.
Okay.
I would like to set one more status date a month out to make sure that the competency restoration training has started. And that there's a firm plan in place. I have spoken with Mr. Barnes, and he is certainly aware of it and working on it.
Okay, good. So, Mr. Smedley, I'll see you back here on March 16th in a month, and we'll just make sure that Mr. Barnes is working with you at that time.
If there's any updates or if I need the court for anything, I will certainly reach out.
Yes, sir. Thank you. Do we need it at 2:30 or you just?
I think it would be another status if we could sub it at 9.
Yes, ma'am. Good question. Thank you.
Judge, I believe Mr. Stevens is ready for Mr. Rashad Thompson.
Okay, good. Mr. Stevens.
Good afternoon, Judge. This is Rashad Thompson in 22 CF 435. We had filed a motion to suppress. We were set for a hearing this afternoon. I did confer with the state, and I believe there may be an announcement.
Okay, to the state.
Judge, based on the conversations that I have had with Mr. Stevens and the attachment to the motion to suppress, my expectation of the testimony that's going to be presented for the motion to suppress hearing today, looking over the recordings from law enforcement that night, where the state's in a difficult position because the attachment to the motion to suppress is something that the state feels that we would need to supply the court with either some kind of picture or a video recording that would reflect the counter to Mr. Stevens' arguments today. Looking at the angles of the video footage that we would be available to supply to the court, the state does not feel that at this point we can overcome the motion to suppress on a good faith basis. So we would ask to no cross the case today.
Okay. Mr. Thompson, then your case is dismissed.
Thank you.
Thank you, sir. Thank you, Mr. Stevens.
And Judge, I also have Tommy Ross on the afternoon docket. She's not here yet, so I'm going to hang around for a few minutes in case she arrives.
Thank you. Ms. Jakewood, do you have a case that you want to take?
Your Honor, mine is a sentencing. I mean, it has a couple of statements, so I don't want to hold anybody else up.
Mr. Gates?
Your Honor, I think
probably better to take mine last, if not towards the end.
Okay. Ms. Jagold, if you want to do the sentencing. And we also have folks, wait a minute, before we do that, we have any counsel that's on Zoom? I don't think so.
Your Honor, I could assist. I believe
Please.
Mr. Collins. I did see his name earlier. I don't recognize him. I've never met him.
Yes, sir. Hello, Mr. Collins.
Yes, sorry, Your Honor.
Mr. Collins, good. You represent Ronald.
Challenge.
You represent Ronald Lowry, correct?
Yes, sir. Who is present on Zoom also, Your Honor.
Okay. And when I did my homework, the notice of hearing just had a big blank when it said after the following and didn't say what was being heard. I assume it's the amended motion to terminate probation. Is that accurate?
Yes, Your Honor, and I don't have an explanation for that other than my office we were insufficient, and I apologize.
I understand. When I do my homework, I just need to make sure that I know what I'm supposed to be doing. So that's why I pointed it out. So on your amended motion to terminate probation, Mr. Collins, please.
Yes, Your Honor. The amended motion pretty much states it, our position. Mr. Lowry was sentenced in 2001 to 30 years in prison. And a consecutive probationary period was ordered of 15 years. He registers four times a year as a sexual offender. He has served basically 10 years of the 15 years probation. Attached to the original motion or the amended was a letter from his parole or probation officer out of Alabama. He's been a model probationee. He has serious health problems, as is indicated in the probation officer's memorandum. And, Your Honor, we are just asking the court for mercy to allow him at this age to be terminated on this probation. He can't do any more than what he's done to show this court and to show the state that he is someone who has paid his debt, and he would continue to do such if this court orders. But it would be in the interest of mercy, Judge, to allow him to terminate at this stage. He's done everything he's supposed to do, and if you want to talk to Mr. Lowry, I have no objection, sir.
Okay. To the state?
Your Honor, the state very much objects to Mr. Lowry being terminated early. Your Honor, actually the statute 948.04 does say a defendant who is placed on probation or community control for a violation of Chapter 794 or Chapter 827 is subject to a maximum level of supervision provided by the supervising agency, and that supervision shall continue through the full term of the court-imposed probation or community control. Your Honor, Mr. Lowry was originally charged with a capital felony, molesting a child under the age of 12, and also lewd and lascivious assault. As a plea bargain, he was allowed to plead to less, so he was not facing life without parole. He was allowed to plead to less. That was a written plea agreement that his attorney, Mr. Pinkerton, Mr. Lowry, and Mr. Fleet entered into. They all signed off on it, a contract, if you will. It specifically stated you will serve 30 years DOC, and then that will be followed by 15 years of probation. That was what everybody agreed to. The victims were on board. We believe, Your Honor, Mr. Lowry has gotten the benefit of that bargain. He didn't go for life without parole. But now he should have to serve the entirety of it out of fairness to the parties, for one thing, but also, Your Honor, by statute. Under the statute, under 794, he cannot, and this was a sexual battery. So the state does oppose it, Your Honor, and we speak for the victims as well.
Okay, thank you. Mr. Collins, do you want to call your client as a witness, or is there anything else you want me to know?
I would like to call Mr. Lowry as a witness, Your Honor, and I would allow you, if you wish, to speak to him and question him as any way you want. You know what's on your mind more than I do, and for me to ask you questions that don't really concern what's on your mind, it might be better if you talk to him.
Well, I did my homework. I read through the amended motion. I read through the letter from the parole board, so I certainly understand that. I don't think I have any any questions that I would ask Mr. Lowry, but if you have something else you want me to know, Mr. Collins, this is your time to do it.
All right, Mr. Lowry, can you hear me? Yes, I can.
Mr. Lowry, first off, if you'll raise your right hand. Mr. Lowry, if you'll raise your right hand.
Yes, sir, I can do that.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Thank you, sir. You can put your hand down. Mr. Collins.
Mr. Lowry, would you let the court know what your health issues are at this time?
Well, I was fortunate to overcome two terminal cancers. One, I have a radical neck surgery on the melanoma. The thyroid was a thyroidectomy. A year ago, I had a very massive hematoma in my abdomen, in which I had to be airflighted up to the University of Alabama in Birmingham, and I went through 3 major emergency surgeries there. I've since gotten an endoscopy, and I'm trying to see if there are ways that can be recovered from that as well. And some issues, of course, with my back, but I still try to go ahead and press on and move forward.
And Mr. Lowry, has probation at any time put your health in jeopardy because of the restrictions that it imposes on you for travel?
Well, of course, I'm not really supposed to remain anywhere overnight to that extent, but on emergency situations, this last time I ended up in the hospital for 10 days, but we have, my wife is, we have a good relationship with our probation officer, Officer Miles, and the staff, and she immediately informed them, and they immediately went to where they had to inform those people in Birmingham, but you know, it's always been an open policy, and we keep contacting each other.
All right, so the answer would be that it hasn't really kept you from getting your medication or your surgeries. However, it's mainly because of your goodwill with the probation officer. Is that correct?
Well, I do think that's the case, yes, sir.
And how old are you, Mr. Lowry?
I'm 72.
All right. Your Honor, I don't have any further questions.
Okay. To the state, any questions for Mr. Lowry?
Not for Mr. Lowry, no, Your Honor. Thank you.
Okay. Thank you. As I was looking at the old docket, there aren't any, the arrest report, there's nothing that shows the facts, the underlying facts of the case. Mr. Collins asking Mr. Lowry about his age, and 72 years old. Tell me anything about the underlying facts.
Your Honor, unfortunately, I'm somewhat familiar with them because we handled a 3850 on this for Mr. Fleet and Mr. Pinkerton years ago. So even though I wasn't the original attorney, these were children that lived in the house. It was an ongoing, repeated, continuous sexual abuse. I mean, we're talking full-blown, not just L&L molestation. The victims had to suffer their whole life with this. There was a lot of mental trauma because at first they weren't believed, but then finally Mr. Lowry was brought to justice, and they did receive that justice, but then they also agreed with the downward departure that would not keep him in prison for life. So because of that ongoing trauma, both as children and then as adults, the state is asking that the court hold them accountable for the rest of the term, because that's really what everybody agreed to, and they have to live with it. Unfortunately, his health is bad, but they've gone through their whole life suffering from what Mr. Lowry did to them.
Understand. Thank you. Mr. Collins, it's your motion. You get the last word.
Your Honor, these types of cases are always very difficult for the court and certainly defense attorneys to monocle out what is justice at this stage. I'd be an idiot to come up here and try to convince anyone that the crimes that Mr. Lowry committed so long ago were not horrific. They were. But we also know there was a reason, and none of us who are present here today really know why the downward departure happened, and he was able to get a very stiff sentence, 30 years in prison, be followed by 15 years probation. We can speculate that there was some responsibility accepted by Mr. Lowry, since there was not a trial, and that did a lot for those young victims of his at that time. Really, I can't argue against that part. What I can argue is for Mr. Lowry at this stage in life. And at this stage in life, he registers 4 times a year, so the monitoring still stays in place. Judge, probation at this point serves no real purpose other than if it's for punishment, and that's a purpose. I don't mean to downgrade, but there's also something in this system, as I've been practicing it for almost 40 years, called there can be mercy if people have done what they're supposed to do and have changed. He's done what he's supposed to do. He can't go back in time. We can't go back in time to change what he did. All he can do is accept responsibility and try to be a better person. That's the best argument I have, Judge. It really is, you do have discretion on this. The law and the issue about a contract are arguable. I'm not going to get into that. I don't know what else to tell you, Judge. I've known Mr. Rowley for a bunch of years, but nobody cares what I think. But I think it would be a merciful act. He served almost 2/3 of probation. He served 30 years in prison. He's going to be monitored 4 times a year. He might not be around much longer. But that's life, Judge. I don't have nothing else.
Okay, thank you. Mr. Lowry,
Sure.
you know, there is competing interest here. One is the contract, the plea agreement. And we're taught in law school and that, you know, the court can't get in the middle and rewrite a contract. But the other side of that in criminal court is the appellate courts say the court can modify probation at any time. So you can't take that away from the court. So it's kind of those two are at odds. I think I have to look at the totality of the situation. On the one hand, Mr. Collins says, the way that I hear it, is probation's really not doing anything to protect society. But yet, on the other hand, there's something that probation's doing that you want to terminate because it's restricting you in some regard or providing additional obligations for you. Based on the totality of what I know, respectfully, the amended motion to terminate probation is denied, so you'll remain on your current supervision. Thank you, sir. Thank you, Mr. Collins.
Thank you.
Thank you, Your Honor. Have a nice day.
Y'all too. Okay, we have other folks that are on Zoom. To the attorneys that are here,
Your Honor, I have several family members for my sentencing on Zoom, not to make statements, but just here to report.
okay. Do you want to take the sentencing now, or is there some other case that may be substantially shorter than this? Yes, sir.
Judge, we have a motion to transfer to division, and Mr. Powell is here.
Good. Mr. Powell, come on up.
Good afternoon, Judge.
Good afternoon. Is this on Brandon Lee Lanou?
Yes, sir, it is.
Good. And Mr. Lanou's back there. I met him earlier.
He's present and approaching. Case number 22.
CF 1856.
And Judge, the state has filed to transfer the division to Judge Ketchel. We are objecting to that at this time.
Okay.
The court has heard a pretrial detention hearing and I believe 2 other bond hearings. You've heard from the victims. You've watched the videos. You've heard from Mr. Lanou's family. There is a co-defendant in the other division. However, this is a case that cannot be tried together because of, I believe, brutal issues. We're asking to let it stay put. It may be more appropriate later to transfer it, but again, if it was going to be tried together, we would move to sever it for those
for those reasons. This also may be a case that results in a plea to the court, and I know you're familiar with this case. You took very detailed notes on our previous hearings. I don't think it's transfer and division usually occurs at kind of an intake process, and this is filed after all of these hearings have taken place. And so I'm objecting to it. I think it should stay put, especially since this is a case where there are brutal issues. And I can tell you, both Mr. Lanou and the co-defendant were at one point in the jail together, and there were different sort of threats being made towards Mr. Lanou. And so just having them on the same docket day, I don't think is a good idea. So I'd object. Again, I may change my opinion later, but I think for right now, we'd ask to keep it with you for all those reasons outlined.
Okay, thank you. To the state?
Your Honor, I think it's very clear what the rules are here. In Administrative Directive 2006-07, which was issued by Judge Barron, it specifically requires that in all cases involving co-defendants, all cases shall, I think that's very important language, be assigned to the division to which the lowest case number is assigned. Please be reminded this case number is 22 CF 1856. The case number in Division 1 is 22 CF 1794. The reason part of that administrative order was given was because it allows us to expect consistency in division assignments, it reduces surprise, and perhaps more importantly, it discourages forum shopping. In this situation right here, all of these pretrial motions, we can't go away from what has been administratively ordered just because there were pretrial detention motions. I think in this case, the co-defendants were granted monetary bonds, and then if I'm not mistaken, they were released from custody. A grand jury then returned an indictment, and they were actually their bond was reinstated and released again. There is nothing in our law that states that this would be the correct action to keep this in this division and keep them separate. As a matter of fact, we have the exact opposite. We have an administrative directive that states that all cases involving co-defendants should be assigned to the division in which the lowest case number is. And I think, as I've stated, that's in Division 1 in case 22 CF 1794. So given those reasons, to expect consistency in the division assignments, to reduce the surprise, and to discourage forum shopping, I don't even think there necessarily should have been a motion on this. This should have been something that automatically happens per the administrative directive. And so for those reasons, we request that this case be allowed to be transferred to Division 1 as the administrative directive states that it should.
Okay, tell me the number. It's 2006, what?
2006-07. There is also an amended directive number 2005-03. And this was done on the 7th day of September in 2006.
And to just do that, I mean, I guess, why are we just now?
The motion for transfer division was filed in October of 22.
Yes.
So it's not like we're just now doing this. This was objected to, and now we're here.
Yeah. I believe it was after, we mentioned forum shopping, I believe that was after a pretrial detention hearing and a bond hearing and everything else. So, like I said, Judge, without rehashing everything, I'd ask it to stay put given the issues I've already outlined.
Okay. Mr. Lanou, I'm going to take it under advisement. I want to read that administrative directive. One of the things in the motion to transfer divisions, and it was interesting, it didn't have the lesser number. That may have been why I flagged it or didn't sign an order administratively. But hearing what that lesser number is, but I can't ask you to follow the rules if I won't follow the rules. So I want to look at that administrative directive. If it is a mandatory shall in there, then I may talk to the administrative judge, Judge Stone, and say, are you aware of anything that says I don't have to do that, or any later administrative directives or administrative rules that come from the chief of the First Circuit, which are higher in priority than administrative directives, which are from the administrative judge for each of the counties in the First Circuit. So I just want to make sure on that. I know that the older administrative directives were a mess. For a long time, they had a lot of different directives that they never took the place of earlier directives. They just amended them, and it was really ugly there for a while. And so I just want to make sure that I know what the rules are. And once I determine that, then that's what I'll base my decision on. If there's not a rule that says that, then your motion will, well, your objection to the motion to transfer will be granted. If there's a rule that requires it to be transferred, then I'll transfer it. And I'll look at that either today or tomorrow, okay? So advisement, let me make a big note where I don't forget. So I'll let you know no later than tomorrow.
Feel free to take your time, Judge. That's all I have this afternoon.
Thank you. Thank you, sir.
Yes, sir.
Have a good day.
You too. Ms. Jacob?
Mr. Stevens has continuing,
Mr. Stevens?
David Stevens on behalf of Tommy Lynn Ross, 22 CF 1386. She was set today for a motion to dismiss. Reached out to her. She lives in Navarre. Her ride fell through. I talked to the state. We're in agreement to leave this set for March 13th as our next pretrial date. We've reached a resolution in the case for misdemeanors, so I'll try to do a written plea and abstention, but if not, we'll resolve it on March 13th.
Okay, sounds good.
That's all I have. Thank you.
Thanks, Mr. Stevens.
May I have Jordan Phillips?
Okay.
And Your Honor, this is a plea. I don't know if Ms. Sandler, however, may have family members may wish to make a statement. And I know Mr. Phillips does wish to make a brief statement as well.
Okay.
Your Honor, there is a family member that would like to make a statement for some remarks himself.
Okay, good. Thank you, ma'am.
If I just may pause for a moment, we just have an amended plea agreement, Your Honor.
Whoa, that was strange. It was only going down on
Only one
side.
side went down all of a sudden? Okay, I'm not going to
ma'am.
move it again, just out of abundance of caution, Judge. Okay, I need you to sign this one. Sign there, take there. It's 260. Sorry, Judge. But you should know that if I touch anything mechanical, it's probably going to break. 216.
Is Antonia Phillips, is that related to you?
Yes, that's Mr. Phillips' sister, Your Honor.
Good, she's just coming over. There she is. But her audio hasn't locked up yet. There it is.
Okay.
Ms. Phillips, welcome. Okay.
All right, and Your Honor, Mr. Phillips, this is Jordan Phillips for the court, Katie Jakewood on his behalf. This case number is 2019 CF 3460. In count one, Mr. Phillips is entering a plea to a lesser included second-degree murder with a firearm. Count two is going to be null prost. It's a necessary element of the first count, so the state is going to announce null prost in that. As to count one, he'll be adjudicated guilty. He'll be sentenced to 40 years in the Department of Corrections. The first 25 years will be a minimum mandatory sentence. He will receive credit for all time served, and that will go back to his initial arrest, which occurred on December 13th, 2019. There are $967 in court costs and a $150 cost of defense. May I approach?
Yes, ma'am. Is that the state's agreement?
That is the state's agreement, Your Honor.
Thank you. Mr. Phillips, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. Mr. Phillips, are you currently under the influence of any drugs, alcohol, or medication?
No.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No.
How far did you go in school?
Graduated high school.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did she answer all of your questions?
Yes, sir.
Are you satisfied with her representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
Yes, sir.
Has anyone forced, threatened, or coerced you into entering the plea?
No, sir.
Has anyone promised you anything other than what Ms. Jakewitz stated today on the record?
No, sir.
On the opposite side of that, Mr. Phillips, has Ms. Jakewitz or anyone else told you, Mr. Phillips, if you don't enter this plea today, you shall be sentenced to 50 years in prison or any other definite sentence?
No, sir.
Well, yeah, to some extent, yes. We did have that discussion because if he was convicted as charged, it was a mandatory life sentence.
Yeah.
So just to make sure the record is clear, we did have that discussion. But as to this, if he was found guilty of second-degree murder, we talked about that as well, that it was 25 years up to life in prison. And so he wasn't told he would be sentenced any definite term if he was found guilty of the lesser included.
Okay.
So I just want to make sure we're clear. I did tell him that we would be a mandatory life sentence if he was convicted as charged.
Mr. Phillips, do you agree with what Ms. Jakewitz just stated today on the record?
Yes, sir.
Do you understand it?
Yes, sir.
Do you still wish to enter the plea?
Yes, sir.
Okay. To the state, you wanted me to hear from someone? No?
Yes, there was a family member that wanted to address the court.
And Your Honor, may we just sit at council table?
Certainly, yes, ma'am. If you'll call your witness to the state.
State calls Mr. Byron Hickey.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Thank you very much. Your Honor, if it please the court, I'd just like to introduce myself once again. My name is Byron Hickey. I'm the uncle of Edgar Williams Jr.'s, Edgar Williams. I'm just tied up right now. Edgar William Jennings III. That was my nephew. I'd just like to say today to Mr. Phillip, this incident have been gut-wrenching for our family. It's torn a big hole in our family. Not having the opportunity to spend quality time with him anymore. I know that these types of incidents are not just damaging to our family, it's been damaging to your family as well. I said in the hearing on Monday, when I was speaking to Mrs. Parker, that Edgar would no longer have the opportunity to spend that quality time with his daughter who loved him dearly. And I understand that you have a young daughter as well. So their lives has been ripped apart because of a decision that you chose to make that night when you took his life. He would no longer be able to attend a father-daughter dance with her. He would no longer be able to coach her on her Little League soccer team,
softball team. Watch her graduate from high school, have her high school prom, not even an opportunity to walk her down the aisle if she decides someday to get married. And because of your actions that night, you strip yourself of those same opportunities with your daughter. And I venture to say that had you had an opportunity to meet him, today again I bring 2 ball caps with me, one from the University of Notre Dame, which was his favorite college team, and the Atlanta Braves, which was one of his favorite professional baseball teams. To just help you get a glimpse of the type of person he was, a kind-hearted man who loved his daughter dearly. And had you got an opportunity to meet him, and he has some friends and his fiance that's in the audience, and my niece is here, my brother-in-law is here, his dad, my wife's here, Sandra, his aunt. This was so traumatic for his mother, she couldn't make it, my sister. And so, had you had an opportunity to meet him, you would have never allowed anyone to convince you of anything that they attempted to convince you of, to get you to do what you did. Because he was just that type of person. He met no strangers wherever he went. He was just that jovial type of person. I mean, just well liked by everybody. And I recall after this had happened, that they did a candlelight visual for him. And the people that showed up in the city of Fort Walton, people from Pensacola that showed up, it was amazing to me that my nephew was loved by so many people. So many people. And when he was taken away from us, it just ripped a big hole in all of our hearts. So I just wanted to just take this opportunity. I won't take up any more time of the courts. I just want to just take this opportunity to say to you, Mr. Phillip, what you did was very devastating for us, and had you given yourself a chance to meet him, you would never chose to do anything like that to harm him. So I say to you, God bless you going forward. And I'd like to say thank you to the courts once again for this opportunity to speak, and also to Mrs. Sattler and her office, and also to the Sheriff Department of this county for their hard work that they did in investigating this case. So thank you very much, and God bless each of you. Thank you.
Mr. Hicks, before you leave, thank you. Thank you for being here. Thanks for being here on Monday. Before you expounded on your background, which when you thank law enforcement, that means that much more to the court. I think you also added a hat to what you didn't have, the Braves hat on Monday, but it does make it personal. But thank you. It means a lot to the court here from the family, and I really appreciate the way that you come across, the respect that you show for the court, but also the emotion that you show for the family. So thank you, sir.
Yes, sir. Thank you, Your Honor.
Yes, sir.
All right. Thank you.
Anything else from the state?
Nothing else from the state.
From the defense? Ms. Jacob?
Yes, Your Honor. Mr. Phillips, I'd like to call Mr. Phillips just to make a statement.
Do you want him to make it from the lectern, or?
Your Honor, I know Mr. Phillips, and he'd like to do it from the witness stand. He'd
Okay.
like to be
Come
able to
on up,
actually
Mr.
make eye
Phillips.
contact.
Yes, sir. Mr. Phillips, you're still under oath.
Dear James family and friends, I understand that my apology can't bring back what I took from you. Nevertheless, I still want to extend my deepest, most sincere apology to all of you and my remorse. I allowed myself to be manipulated to do something that I knew was wrong and took someone that you love most. I allowed my anger for certain types of situations to blame me to do something terrible, and I regret every minute of it. I wish I could go back and not even put myself in someone else's business that did not concern me. I have wronged your family in the deepest way possible, something I myself would find unforgivable, and I completely understand if you never forgive me. All I'm asking is that, inshallah, one day you do forgive me. Inshallah means God willing, and forgive me and my family. By doing what I did, I placed a black smudge on my family's name, and my actions, by all fault of my own, caused your family pain, and for your family to hate or dislike mine by default, unintentionally. I found out what I thought was going on was further from the truth, and I had no right to take a life that was made sacred by Allah. And for many nights since then, I have been praying for Allah's forgiveness and mercy, because my religion of Islam believes in an eye for an eye. If I had wronged you in the way that I did, my life was yours to take, but you showed me mercy through an act of charity by not taking what you had every right to take. For that, I am forever grateful, for not deepening the pain between our two families and our friend, especially for the two little queens who will suffer the most, our daughters and your granddaughter, Layla, as well as my daughter, Catalina. Nothing pains me more than looking you in your eyes, Mr. and Mrs. Jennings, and knowing I took a little girl's first love away from her father, and that I can't bring him back. I can't say I apologize enough to lessen that hurt, wishing I could do so bad. And for the rest of my life, I have to live with that, as well as thinking about how I have to explain to my first child that I can't be there to watch her grow up and be there for her like I would like to, and that your son, Layla's father, Edgar, can't ever explain that to his daughter, forcing you to have the most difficult conversation you never wanted to have. With everything out in the open, there is no excuse, no justification that can make what I did be right by any means. I let my anger turn into rage, which in turn made me act on emotion, putting my nose in matters that had nothing to do with me. To Layla, I am most apologetic to you from the bottom of my heart. You did nothing to deserve this. For every night or every day that you yearn for your father, I apologize sincerely. I hope and pray one day that you find it in your heart to forgive me. I apologize for making one of your yearly born days one of the worst days of your life, and there's nothing I can say or do that will make it better or change the terrible memory I have implanted into your life. I can never look you in your eyes knowing the pain I caused you or how badly I had scarred you. It breaks my heart knowing the road you have to travel growing up without your parents, something I'm semi-familiar with losing my mother at the age of 3 to an aneurysm, a pain I still haven't fully healed from. So knowing I forced you to experience the same pain, though different circumstances, it kills me inside. I'm so terribly sorry. I pray, inshallah, God willing, that you still blossom into the beautiful little queen that your father always imagined and dreamed you would be. Though he isn't here with you, he is always in your heart. Never forget that. And again, I am terribly sorry for my part in taking your father from you. I have fully embraced Islam in my heart and in my life, making the strides to better my life, not only for my sake, but for Allah's sake. And when I'm released, be able to be a better father to my daughter and to make her eventually proud to be called my daughter. I thank you for showing me mercy and for your act of charity of sparing my life. I thank you for allowing me to express my deepest apologies and allowing me to give you some type of closure, even though I can't change or mend your pain. Assalamu alaikum wa rahmatullahi wa barakatuh, which means peace be unto you and mercy of Allah and blessing of Allah. Sincerely, Jordan Phillips.
Yes, sir. You can step down. Thank you.
And Your Honor, that's all we have.
Anything else from the state?
Nothing from the state, Your Honor.
Thank you. Mr. Phillips, it's very, very seldom that after a plea agreement is reached, that the defendant takes the stand and talks to the victims. And so I just want to acknowledge that. That's unique. Mr. Phillips, you're adjudicated guilty. You're sentenced to 40 years with the Department of Corrections with credit for all time served, beginning, at least starting no later than December 13th of 2019. So if there's time that's before that, you get credit for that also. The first 25 years are a mandatory minimum, so you'll serve day for day for that period of time. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. There's also a $150 public defense fee. Those amounts will go to a judgment. That's on count 1. Count 2 is dismissed. Mr. Phillips, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, sir.
And Your Honor, the state would ask to reserve on restitution.
Okay. The court does award restitution, but reserves jurisdiction to determine the amount of restitution. Yes, ma'am.
Can I have that statute number for the lesser included?
Yes, can I provide it to you in a moment? Thank you. And Your Honor, that's all I have this afternoon, if I may be excused.
Yes, ma'am, Ms. Jacob.
Thank you.
We'll take a 10-minute recess, and then we'll come back and finish up the afternoon. So we're in recess for 10 minutes.
All rise, please. Court's in recess.